The EEOC basically is responsible for enforcing federal laws that makes it illegal to discriminate against job applicants or employees based on race, color, religion, sex, pregnancy or related conditions, gender identity, sexual orientation. This in bracket has been increased because of the laws over time that has included things like gender identity, sexual orientation in the United States. Now, national origin, age, 40 or older, disability, genetic information. Most employers with at least 15 employees are covered by EEOC laws, 20 employees in the case of age discrimination. Most labor unions, employment agencies are covered. It applies to all work situations, hiring, firing, all of that. Now, what I want us to do is to go to the laws enforced by the EEOC. And I'll encourage you to do this as well if you find this type of thing interesting. I also read a lot of the cases that they've had to handle in terms of the employers that they sued and the basis on which they sued them and things like that. Now, it talks here about, let me see. Let's look at the federal laws. And you see here, the number one is this Title VII, which we talked about, where you cannot discriminate based on race, color, religion, national origin, or sex. And it says that it makes it illegal to also retaliate against someone who complains. And the law also requires that employers reasonably accommodate applicant employees sincerely held religious practices. For example, if it was a job on Sunday and I'm like, no, I'm a Christian, I need to work on I need to go to church on Sunday, the employer should, as much as possible, reasonably accommodate my request, unless doing so would impose an undue hardship on the operation of that employer's business. So that's kind of like a brief overview of Title VII. Now, there's another law called the Pregnancy Discrimination Act. It's illegal to discriminate against a woman because of pregnancy, childbirth, or a medical condition related to pregnancy or childbirth. You cannot retaliate. Almost all those laws, all of them say you cannot retaliate. So you cannot retaliate against a person because they complained about discrimination. The Equal Pay Act has to do with cases. Okay, so we're going to talk in depth about one particular case whereby what used to happen in America is men were given more money. Let's say a man and a woman, they did the same job, they are performing well, but men were given more money than women because one employer said that, you know, the man has a family to take care of. The woman is usually not the breadwinner. Her husband is the one that takes care of her. So those were the justifications. But this law was put in place to say, excuse me, it's illegal to pay different wages to men and women if they perform equal work in the same workplace. So the law makes it illegal to retaliate against a person because they complained. Now, Age Discrimination in Employment Act protects people who are 40 years or older from discrimination because of age. The law makes it illegal to retaliate as well. Now, Title I of the Americans with Disabilities Act of 1990. So in terms of ADA, this one that EEOC handles is Title I, and basically illegal to discriminate against a qualified person who has a disability. In the private sector, state, local government, it's illegal to discriminate as well. Now, Section 102 and 103 of the Civil Rights Act of 1991, this is an amendment to this present law we're talking about, the Civil Rights Act of 1964, and it amended Title VII and the ADA to permit jury trials. So before, juries were not allowed, and a jury is where you bring people from the citizens of the country that are, you know, just normal citizens. You bring them into the court, you tell them about this case, they hear from the plaintiff, those who are bringing the case to say someone did something against me, or you hear from the defendant, those who have to defend themselves against what the plaintiff is saying. And then the jury, those people who should be reasonable citizens, then decide whether it's actually something that should go for the plaintiff, whether they're deciding for the plaintiff or they're deciding for the defendant. So it allowed these jury trials, and not just the judge saying that this is what I think, because some of those judges as well were racist or had their own agendas and things like that. And then you have compensatory and punitive damage awards in intentional discrimination cases. We talked about that. Then, if you notice, when we talked about OFCCP, we said that it was Section 503 that OFCCP of the Rehabilitation Act handled. Now, when it comes to Section 501, 505, that's handled by the EEOC. It also has to do with you cannot discriminate against a qualified person with a disability in the federal government. So this is specific to the federal government. That of the OFCCP has to do with any employer that has federal government contracts. But this one has to do with anyone who is in the federal government. You cannot, or applying to the federal government, you cannot discriminate against a qualified person with a disability. Now, GINA is Genetic Information Non-Discrimination Act. Now, because most employers provide health care, health insurance for their employees, you see that it's important, it's possible for the employer to have genetic information of their employees to be able to even determine if someone would likely have diabetes, someone would likely have cancer, or things like that based on that genetic information. And this is saying that it's illegal to discriminate against employees or applicants because of genetic information. Because what was happening is because those employers were getting access to information that had to do with genetic information, they were beginning to preempt what would most likely happen to that individual, or even know that, oh, this individual probably has cancer, or this, things like that. And then they would fire those people based on that genetic information. So this law was put in place to say you cannot discriminate against people because of that genetic information. It's illegal to retaliate as well. Then you have this law, which is pretty new, just 2022, Pregnant Workers Fairness Act of 2022. And it's you have the Pregnancy Discrimination Act, but this one is saying that you must provide a reasonable accommodation to a qualified worker, known limitation related to pregnancy, childbirth, except it creates an undue hardship. So this is saying that we want you to now start providing reasonable accommodation for pregnant women. If they need maybe some time off, or if they need a different type of thing happening to their position, maybe you want to give them a position that is easier on them, then that employer should provide that reasonable accommodation. But always remember, reasonable accommodation is only allowed, when there is not an undue hardship.